what's happening is that the family court is not in a great place. It's not in a great place. You know, if we put aside for a minute the decisions that are being made in family court, and you know, nobody's ever going to be happy with the decision if it goes against them. Why would they? So if we put that to one side, we then turn ourselves to the situation of the management of family court, the execution of family court, and we have some serious issues. Emails take ages, days, sometimes weeks in order to be processed and looked at by anybody. Consequently, if you're putting in, you know, a document that you want it to be in your next hearing in a couple of days' time, because obviously something has happened and you now need to sort of update the court, the likelihood is that that document is not going to be available. And it's not going to be available because nobody's picked it up, nobody's processed it. Or if they have picked it up, it doesn't arrive in the right place. Let me give you an example. I was in court very recently, and we had made a submission to the court, a position statement that explained to the court, obviously, our latest position and updated them on a few issues. It was important, otherwise what's the point of writing it? We go into the court, we address the bench, and we ask whether, you know, obviously just check that they've obviously had the position statement, obviously they've all had a chance to read it because it's quite key. We get advised by the legal advisor that yes, the court can confirm that the position statement has been received. It was received 3 days prior. It was received 3 days prior, but it hadn't been made available to the bench today, so they hadn't seen it. And the stance of the bench when asked about this was, quite frankly, well, we're a bit short on time, so we're not going to see it. In which case, what is the point? What is the point of legal process if we're not going to bother to consider the documents that are relevant to the case? Court orders coming out. Court orders come out, they've got mistakes on them. They've got spelling mistakes on them. They've got detail errors on them. They've got detail on them that was never even brought up in court because they've been written by the other side in order to suit their purpose. And when they've got in front of a judge or a magistrate to be considered and signed off, they haven't bothered to pick up on the fact that there's been additional detail added. That detail could be quite key. That detail could be pivotal to the next decisions that are made in court. So again, what's the point? What is the point if you're essentially just going to write the order that you'd quite like to see rather than the order that's in any way representative of what happened in the hearing? That is happening. Let me talk to you about a little bugbear that I have. The bugbear is time. I have noticed that the court now, whoever is writing the orders, producing the orders, putting them out the door, and this is right across the court system, has absolutely no idea of the difference between the 12-hour clock and the 24-hour clock. The number of orders I now get on my desk that say that the next hearing will take place on a particular day at 1400 p.m. or 1500 p.m. or 1000 a.m. Now, I'm sorry, folks, but it's fairly basic that the 24-hour clock and the 12-hour clock cannot be mixed. You can't have 1400 hours PM. That time does not exist. That is a mix of two completely different time systems. At the very least, can we actually be having the time correct? If it's a 2 o'clock hearing, 2 p.m. hearing, it's a 2 p.m. hearing. If you want to detail the hearing as being at 1400 hours, it's at 1400 hours. That's fine. Either system will do, but don't mix them up. Don't mix them up. What's the point in that? That just demonstrates incompetence, is all that demonstrates. Where else are we going to go? The fact that courts order that the hearings are going to take place in a particular place, but on the order they don't bother giving you the address. You know, oh, you're in Leicester Family Court. Well, okay, well that's great, but unfortunately Leicester Family Court functions out of two different buildings, and those two different buildings are 300 metres, 400 metres apart. So which one I own, which one should I go to? It's very basic stuff, but the administrative process is falling down, and that's over and above the issue of the fact that orders are not being released. Orders are being processed, so a hearing takes place, order is produced regardless of whether it's accurate or not, regardless of whether the content is correct or not, but the order is produced, but then it's just not released to anybody. Nobody receives it. So it's then a second guess. The number of occasions over the last 12 months where me or the client has been contacted to say, where are you? Well, your hearing's today, your hearing's now, where are you? Well, we don't know, we haven't had it. So how can we react? How can we attend to something that we're unaware of? So at the moment, life is difficult, and I don't see life getting any easier anytime soon, because the quality of the administrative process, as much as anything else, and the case management process in court is eroding. It is eroding by the month, and things are happening which just make the court, aside from being already an emotionally distressing place to be, it's now a frustrating place to be, because you're fighting the system, the admin system, as much as you are trying to fight your case.